Thank you very much for that introduction and for a reminder of my debt to public education. I never cease to speak up for public schools, which are sometimes not sufficiently appreciated. They educate 67% of our people, and they educate them in good values of citizenship and democracy. I acknowledge the traditional custodians of the land, not in a perfunctory way, but wholeheartedly and sincerely, remembering the many great wrongs that were done to the Aboriginal people and perhaps are still done to the Aboriginal people by the law of Australia. And it is appropriate that we should pause and reflect upon the fact that law, though it often searches for justice, sometimes fails to discover it. I also want to acknowledge the wonderful contributions of the University of Wollongong. I first came here when I was President of the Court of Appeal of New South Wales because one of my colleagues, Justice Robert Hope, was the Chancellor of the university, and he was certainly one of, if not the brightest man I ever knew. Sharp as a tack, but also very generous spirited. When I was appointed the President, he had every expectation that the call would have gone to him, but it came to me. And he never let that get in the way of our relationship. He was a man of big spirit, of great service, a very intelligent man, a man who you would call a liberal person, a person who believed in freedom and liberal ideas. And his spirit is very much alive with me as I'm back here on this campus. I've come to the campus many times. I've spoken to the law students in this very lecture hall, and I had the most unusual experience of being asked for a lot of signatures from the law students outside the lecture hall, and one female student, not having a piece of paper with her, said that I should sign my autograph on her bodice, and she thereupon revealed a semi-naked breast. I was then faced with one of those very difficult decisions in life. Do you sort of say, well, that's a very great compliment, but I don't think I really should. But I thought, oh, hang it. And I got to, and I signed away with a great flourish. It's probably been photographed and will be pulled out against me for use in evidence when I face the ultimate trial. I also pay my respects to the Deputy Vice-Chancellor, the Dean of Law, Professor McNamara, and to the law school here. It's a very fine law school. A little bit conservative, but it's a very good law school, and I chose my associates in the High Court. They're the young law graduates who work with the justices by a process of rigorous advertisement. Didn't believe in the old boy network. I believed in a proper system of equal opportunity selection, and it so worked out that the only law schools of this nation who got 2 associates in the High Court in my period were the University of Sydney and the University of Wollongong. And I had 2 wonderful graduates from this university, one of whom, Elisa Accioni, I believe gave you a lecture in an earlier phase of this series before Christmas. She was outstanding. Her great expertise was weeds at that stage, weeds. But it's an aspect of the law of environment which she's still very much involved in, and she is a really brilliant graduate of this law school. The other graduate was James Goodcamp, who is at Magdalen College in Oxford. He won fabulous scholarships. He is published everywhere. He's brilliant. he's a bit like me. He needs to get a life. And I keep telling him, get a life, James, get a life. But he then says, who are you to tell me that? Which is not a bad answer. It's true, as the acting Vice-Chancellor said, that there was a bit of a glitch in the arrangements for my coming here today. But when I have to go out tomorrow to Chiang Mai for a big conference on a new human rights initiative of ASEAN, the Association of Southeast Asian Nations. Quite a tricky issue, and I'll be flying out tomorrow, so I had 1,000 things to do. But I raised the question, as one always does, with my father, because realise that as I'm only a young person, I need to get advice on many things, and I always go back to my father when I have big moral dilemma. So I said, I've got 1,000 things to do. I didn't expect to be down there in Wollongong. And he said, John Hatton, you say? John Hatton? I said, yes, he's involved in, he's organ. If John Hatton wants you down there, you've got to go. And so that is the truth of the matter. And so I was there last night having dinner again with my father. He's still driving. He's 93, as sharp as a tack. And he said, are you going tomorrow? And I said, yes, Dad, I'll be there. So for John Hatton, I am here, and for the University of Wollongong, and for all of you. Now, if you've come here today expecting me to talk on the subject of corruption and of local government in the Wollongong area, if you expect me to get into that sort of area, well, I'm afraid you're going to be disappointed, because A, it wouldn't be appropriate for a recently passed Justice of the High Court to do that, and B, I don't really know about it, so it wouldn't be. The second wouldn't necessarily stop me from talking, but the first definitely would, and therefore I'm not going to deal with that issue, and others will have to do that. I'm going to come at the issues of this series of lectures in a very particular way. You want me at the microphone, do you? Oh, my natural inclination is to wander. I think we should all wander. We should all wander from the fixed point. We should all be willing to think outside the square or outside the circle. But if those who are watching lose the image, well, I've just got to behave myself. The issues that I want to address are slightly different, but I want to start with a sort of declaration, because you would have thought that a person who served for 35 years in the judiciary of our country at various levels in different courts, you would have thought that such a person would have been absolutely committed to and infatuated with the legal system and with the courts and with the judiciary. Well, I've always had a certain skepticism about the law. I recognise its many strengths, and I recognise the many strengths of the courts of law, but I've always had a certain skepticism about it. And I ask myself, is this skepticism born of a natural Irish contrasuggestibility? Well, there might be a little bit of that in it, because it's in the nature of people who are genetically Irish, whether of the Catholic South or the Protestant North, to be sceptical and questioning. And I think that's a very good thing. But I don't really attribute it to that. I attribute it to two youthful experiences, and I'm just going to mention them to you because they illustrate a theme I want to develop in the course of these remarks. The first experience I had, really, of the High Court of Australia occurred when I was about 10 or 11. I was a very precocious child, as the acting Vice-Chancellor boastfully said I went to Fort Street, but before I was there, in 1949, 1950, I was at the Summerhill Opportunity School in Sydney, and at that school I learned that a very strange thing was happening in Australia. It was the passage of legislation by the Federal Parliament called the Communist Party Dissolution Act, 1950. So it's exactly 60 years ago this year. The Menzies government had been elected on the 2nd of December 1949. I was then aged 9 years of age, and Mr Menzies came into power, bringing the coalition back into power with the promise to put value back in the pound, to remove the taxes on petrol, and to provide child endowment for firstborn children. Because I was a firstborn child, and because I hated the discrimination that was visited on me, that my mother didn't have those little forms. I don't know if any of you in this audience remember the form that we got for endowment, but firstborn children didn't get it. And so Mr Menzies was elected. But one of the most important planks in his platform for which he was elected was to ban the Communist Party of Australia. And so it was that one of the first pieces of legislation enacted by the Menzies government, Menzies-Fadden government, was the Communist Party Dissolution Act. And the reason why I, a boy of 9, knew about this was because my grandmother, during the war, the latter part of the war, had remarried, and she had remarried the treasurer of the Australian Communist Party. It was not, shall we say, a good career move, but it was an affair of the heart, and I got to know at the age of 9 the treasurer of the Australian Communist Party. His pseudonym was Jack Simpson, because he'd grown up in New Zealand by name Morris Flynn. And the Flynn family were all devout Roman Catholics in New Zealand, and they were very ashamed of their wayward son, Morris, who had gone and fought in Gallipoli. He was one of the original Anzacs, and he went to fight in the Somme after the withdrawal from Gallipoli, and he won the military medal, which is a very high military decoration. He was a brave soldier, a courageous man, and he got the military medal from King George V at Buckingham Palace in 1918. So he was a very distinguished man. But after the war, he became very disillusioned with what he saw as the errors of the capitalist system, all the killing that he'd seen, all his mates dead in the mud of the Somme. And he threw away his medals and he became a communist. And in a sense, this was Jack Simpson's religion. And I have to tell you, I was a young boy, only 9, 10, when these events happened. I can't remember many people in my life who have seemed more stalwart, honourable, honest, idealistic, futuristic, good. And I remember him in their home in Tempe, sitting there listening to the horses. Now that was not permitted in the rather Protestant environment in which I was brought up, in Concord, and with a glass of beer. That was definitely very unusual behaviour. And so in many ways, beer, horses and communism, I got to know this rather unusual Australian. But I knew that something was up, and something not very nice was happening. And I got the message. I didn't really understand, of course, at that age, all the details of it, but I knew that it wasn't a good look for my Uncle Jack, as I'd come to call him. And my father tried to explain that this would mean Uncle Jack would have to go into hiding, carrying with him the bullion of the Communist Party of Australia. Not that I think that was very much, but he was planning to take it and to avoid the capture of the money and the wherewithal of the Communist Party. Anyway, the legislation was challenged in the High Court of Australia, the court on which I was later to serve. And so the case came before the High Court. And one day I'm going to go into the State Library and look up the old back issues of Tribune, the newspaper of the Communist Party. But my father has told me that Jack Simpson and the leaders of the Communist Party never believed for a minute that the High Court was going to strike down the legislation. They never believed that the running lapdogs of the capitalist classes, the judges, would strike down this legislation. It was enormously popular legislation, and the Menzies government had a mandate. It was specifically in the 1949 campaign, and other countries, including the United States of America, had banned the Communist Party under the so-called Smith Act, and therefore it was a very popular piece of legislation, and the Commos didn't think that the High Court was going to strike it down. But there it was in 1951, by a majority of 5 justices to 1, the High Court struck down the validity of the Communist Party Dissolution Act. And then the next phase of the battle arose, and that was the endeavour by the Menzies government in Parliament to enact an amendment to the Constitution to override the decision of the High Court. But to do that, they had to not only get it through Parliament, which they did, but they had to get the approval of the people at a referendum. And you know that it's very difficult to get an approval of the people at a referendum because Australians, rather wisely in my view generally, have been a bit cautious about changing the Constitution. And so that went to the people, and Dr. Evatt fought the referendum as he had the case in the High Court. It wasn't expected that he would win that battle because at the beginning of the campaign, 80% of the people of Australia favoured the amendment to the Constitution. But the net result was that when the votes were counted in September 1951, the people of Australia narrowly defeated the attempt to amend the Constitution. So what inference did I draw from that experience at a tender age? Well, first of all, I knew that there was this strange place somewhere far away in Melbourne, I thought, as it was, the High Court was then based in Melbourne, which had made life much better for my Uncle Jack, and he didn't have to pick up his suitcases and flee to the country to hide the bullion of the Communist Party. He could just go on with his own affairs. And so that taught me a number of lessons in life. First, it taught me that the law can sometimes be a rather puzzling and sometimes even apparently an unjust instrument. I mean, why should we ban the communists even if we thought their views were crazy? There are many people's views, a lot of religious views we think are crazy, but you don't go around banning them. And that was ultimately the wise view that the High Court of Australia and the people of Australia at the referendum upheld. So that taught me to be a bit sceptical about the law and to be sceptical about the way the law can sometimes be whipped up and that you can get a great deal of enthusiasm for a law, to ban it, to prohibit it, to jail them, to throw them into the locker and throw away the key. That can sometimes happen. You can get these passions, and sometimes it's a very good thing that we have courts and we have a constitution and we have laws that are obeyed. But that law isn't always just, and that it isn't always wise, and sometimes it overreaches itself. So that's a little lesson I learned from the experience of my Uncle Jack. He lived on until the late 1950s. He lived through the experience of hearing Khrushchev denounce Stalin. I think that was in '56. He became very disillusioned with the Communist Party, as he had earlier been disillusioned with the Catholic Church. And I rather felt for him, because by the time he died I was about 17 or so. I went to his funeral. I remember his coffin with the red flag on it. I knew very little about all the people who were there, but that was just a little of my experience in life, and it did teach me to be a little critical of the law, because the law sometimes overreaches itself. A second experience was a much more personal one, because at about the time that I was learning about the Communist Party legislation, I was coming to puberty. And as I came to puberty, I discovered that I was gay. And that was not a good discovery at all back in 1951, because at that time it was, first of all, a criminal offence to do anything about your sexuality. Secondly, it was a matter where the law placed a whole lot of burdens on individuals, disadvantages. It exposed them to a whole series of attempts by authorities to entrap them. Very famous people, Claudio Arrau, the great Chilean pianist, came to Australia and was picked up by a policeman, a handsome young policeman who made a pass at him, winked at him. And that led to a great scandal at the time. You lived in a world where you thought any day you might turn up on the front page of the Daily Mirror. The Daily Mirror and the Daily Sun, you've probably all forgotten about them, but they were, well, you're such a young audience, you don't know these things. I've got to tell you these things, as an old gent has got to tell you about the Daily Mirror and the Daily Sun. They were, well, they weren't what you'd call quality newspapers. But that was not a good discovery. And I remember going to my law school lectures in criminal law, and we were taught criminal law by Mr. Vernon Triet, QC, who was the leader of the state opposition. That just shows how different politics was in those days. He actually, in his spare time, taught the classes criminal law. And I remember the way he used to come into the class, and I don't know if anybody else remembers this, he used to toss his hat down on, he would somehow get his hat and toss it, and would always land on the chair. He was an expert, he probably played basketball, but he got it onto the chair and then he would launch into it, and then he'd reach that point in the lectures where he talked about the abominable crime and the unnatural offences and the shamefulness of it all. And my eyes would fall to the ground. Our lectures for that subject were in the old Phillip Street Theatre in Phillip Street, where some of you might have gone for the musicals and the other. This is where Barry Humphries made his first appearance, in the Phillip Street Theatre. Well, so did Vernon Triet. And he taught us about the abominable crime, the unnatural offences. And that brought home to me very particularly and in a very personal way that the criminal law was sometimes, shall we say, a trifle irrational and unfair. And it didn't seem as though there was very much that I could do about it. It was just something I would have to live with. Well, we know that as a result of actions which were taken, first of all in England, well, I suppose you could start first of all in America with Dr. Kinsey and his inquiry into the variety of human sexual experience. And then the inquiry in the Royal Commission in England, the Wolfenden inquiry under Sir John Wolfenden. And then the change of the law in England on homosexual offences, and then the alteration of the law in various parts of Australia on homosexual offences. Step by step in Australia we changed the law in every part of the nation except Tasmania. Tasmania held out. The Apple Isle was going to have nothing to do with this nonsense. It was going to hold fast to the biblical injunction. The unnatural and abominable offences would remain. And I was telephoned. I was then the President of the Court of Appeal of New South Wales, and two young gay activists in Tasmania rang me up and said, we're thinking of taking this provision in the Tasmanian law to Geneva to complain to the United Nations. And do you think we should do that? And I said, I don't think that's a good idea. I said that because there was no way the Tasmanian law was ever going to come before me in the Court of Appeal of New South Wales. And so I thought, well, I'll give them a frank advice. You're not being prosecuted. You're not being haunted by the police. You're not, they don't really enforce the law. And above all, there is no way that the Human Rights Committee of the United Nations of the world is going to get into a battle of this kind at this stage, because they speak for Iran and for all sorts of countries with very conservative regimes. There's no way they're going to touch it. They won't touch it with a barge pole, I said. Won't touch it with a barge pole. So they said, thank you very much, Judge, thank you very much. And they put the phone down and they went straight to Geneva and they won the case. Now, doesn't that prove how important courage is? Doesn't that prove how important individual initiative can be? Doesn't that prove how if you're in official jobs, you tend to get those blinkers on? I even, you won't believe this, I even go around with a pair of blinkers because I thought I'd have a bit of a snooze in the car on the way back. But people can have institutional blinkers on. But these two guys said, well, we're getting nowhere in Tasmania. We don't have a Bill of Rights in Australia, but we've got the new International Covenant on Civil and Political Rights. We are not being prosecuted, but we're being persecuted. We don't want to have this hanging over our head. We are citizens of this country, and we are sick to death of having people look down at us because of these silly laws. They've got to go. They've gone in England. They've gone everywhere else in Australia. They're not good for the struggle against HIV/AIDS because it makes people closeted and unable to get the message. It's a very bad thing, and we want to get rid of it, and we're very grateful for your advice, but we're going to do absolutely the opposite, and we're going to go to Geneva, and they won. Now, there's a sequel to this story, because in 1996, when I had just been appointed to the High Court of Australia, the decision had been made in Geneva in favour of Rodney Croome and Nick Tiernan, and they then brought proceedings to have the Tasmanian law declared unconstitutional, because the federal parliament had enacted a law to give effect to the decision of the Human Rights Committee of the United Nations. So it was a battle between the validity of the federal law and the validity of the Tasmanian state law. And of course I couldn't sit on the case because I'd talked to these two men who were parties to the case before I ever thought it would end up before me in a court. But it just goes to show, it also proves how you never know where life is going to take you. And it also perhaps teaches the lesson that judges should keep their big trap shut, because you never know when the problem might come up later on. However, all honour was saved. I didn't sit in the case. There was a preliminary skirmish. The High Court upheld the right of the two men to bring their action, and the Tasmanian government and Parliament changed its mind, amended the law, and so all of those laws were removed from one part of Australia to another, so there aren't any of those laws left. So this was the background, this was the baggage that I brought to my experience in the law. But it didn't finish there, because when I went to university, at the University of Sydney, I accidentally became involved in student politics. I won't tell you the sordid details of how I got involved in student affairs, but I did, and that made me an active lawyer. I was a young lawyer by this stage, appearing for students in the Vietnam War protests and a whole series of actions. You have no idea the judges and Queen's Counsel in Australia who I saved from being struck off the list before they'd ever got onto the list. And they, nonetheless, their reputations were saved, they were acquitted, and do any of you remember Eric Boehm? Now, Eric Boehm used to attack me day in, day out. Come off your high horse, Mr. Kirby. Come down from your high horse. Stop preaching to us. We're not interested in what a young whippersnapper student has to say. Well, I soon taught him a few things. But the fact is that by getting involved in the student activities, I came to the notice of a few people who thought, well, this is an interesting sort of a character. He's standing up for what he believes in. And from there, I became involved in the Council for Civil Liberties. Now, there's a real danger, and if there's anyone up the back who's thinking of joining the Council for Civil Liberties, the problem if you join the Council for Civil Liberties is almost certainly 20 years later, you're going to end up, as Rumpole says, with your trotters in the trough. Almost everybody who got involved on the committee of the Council for Civil Liberties ended up a judge. It's extraordinary. I mean, all those people I sat with round the table of the Council for Civil Liberties ended up in one place. Justice Hope was one of them. He was the president of the Council for Civil Liberties. All of these troublemakers and stirrers who were taking on the issues of the day ended up in the judiciary. And not a bad thing that they did, because it meant that we got into the judiciary a leavening of people who'd seen that the law wasn't always good, it wasn't always fair, that police weren't always truthful, that things weren't always just. And so that really drew to my notice what I suppose I intuitively knew, but what is certainly demonstrated, I think, in a country like Australia, that civil society organisations are the essence of our freedom. I mean, Robert Putnam, the American sociologist, has written about this, about how if you want to know how free a society is, look to how many community organisations they have. Village glee clubs, Rotary clubs, Lions clubs, knitting clubs, mothers' union groups, civil liberties organisations. All of these are the definition of freedom. It's not political parties. As I'm going to suggest to you, political parties can sometimes be a bit of a problem for liberty, but it's citizens getting off their backsides, getting involved in community groups and becoming stirrers and shakers. And I rather suggest, or rather I infer, that all of you are here present because you're of the stirring and shaking variety. And that's a very good thing. And that is why, one of the main reasons that I took my father's advice, which I would have had to do anyway, and came down here to be with you today, because that is exactly my attitude to Australia. We have good institutions, we can make them better. We have the rule of law and parliamentary democracy. They are a bit flawed in some respects. We can make it better. And how do you make it better? You make it better by getting off your bottom, joining organisations and doing things, including political parties. But not just political parties. It isn't all monochrome. It isn't all in Parliament. It's in the whole freedom of citizens to be engaged with a whole range of organisations. And it's interesting. It sometimes is infuriating, especially all those committee meetings I've been to. When I was a young man, instead of being out and about and at dances and having fun, what was I doing? I was chairing committees, one after another. I am a great committee chairman, but what a sacrifice I made to do that, of all these bodies that I took part in. But it is the way to advance freedom, because it's the way in which you have people who will stand up for the values that are important in our civic community. So these are the backgrounds with which I approach the law. Now, when I was appointed 36 years ago to my first judicial post, I came to a judiciary which I honoured and I still honour. We're fortunate in Australia that we have judges who are learned and hard-working, serious-minded and honest people. You can really count the number of countries in the world where the judiciary is uncorrupted on the fingers of a couple of hands. But I believe, my experience is, and this I told to groups of judges from Indonesia or anywhere else that came to see me, the proudest thing I can say about my 35 years as a judge is I never once had anybody approach me with a brown paper envelope. I never had anybody hint or suggest that this would be a good career move if I reached a decision this way or that way. I never had any offers of advancement or promotion or some advantage if I decided a case in a particular way. I never had pressure applied by the big end of town, nor by a trade union. Occasionally we would get a little helpful advice from the editorials of Mr. Murdoch's newspapers, but we could ignore those if we wanted to. But we never had the sort of corruption that exists in most countries of the world, unfortunately. There have been one or two very celebrated cases in Australia. They're celebrated because they are so unusual. One of them involved the former Chief Magistrate of New South Wales, Mr. Murray Farquhar, who, by the way, had good qualities. I mean, when you sit on a bench for 35 years, you learn nothing is black and white. Everything is various shades of grey. And Murray Farquhar actually was one of the first judicial officers in the state and in Australia who was interested in criminology. And he would take a very active part in the Institute of Criminology. But in any case, as a result of the strict Royal Commission, it was found that he was too closely associated with some of the people who might be able to put pressure on him, and subsequently he was convicted of criminal offences and he was jailed. And he was the first judicial officer in Australia to serve a period of time in jail. There was also Justice Vasta in Queensland, and he was the first Supreme Court judge, state Supreme Court judge. But you can count these cases on the fingers of one hand. Accusations were made against Lionel Murphy, and he was convicted at his first trial, but he was subsequently acquitted at his second trial. So that it can be said truly that in Australia the judiciary is not corrupted, certainly not corrupted in the financial sense or in the ordinary way in which we would use the word corruption. And that is a good thing, it's a strong thing, and it's something we have to keep in this country. We've got to make sure that that is maintained. Indeed, later this month, I go to Lusaka in Zambia for a conference of a group of which I am the rapporteur. It's called the Judicial Integrity Group of the United Nations Office on Drugs and Crime. And its purpose is to try to spread principles for the protection of integrity of the judiciary in countries where it is not taken for granted that the judges are people of integrity and not on the take, or where, as may sometimes more frequently happen, the staff of the registries can say, well, if you give me a bit of money, I'll push that before Justice X, or I'll hurry that along the process. That's a big problem in many countries, countries of great poverty and great temptations to loss of integrity. But in Australia, we don't have that problem. The type of problem we have in Australia is much more a shade of grey. And I'm going to tell you a case that came before me in the High Court of Australia which illustrates the sort of problem which we can get in the courts. These were the facts of the case. A judge was sitting in a case involving a claim by a farmer against a bank. The bank had given a mortgage and the farmer was the mortgagor, the bank the mortgagee. And the farmer defaulted. So the bank wanted to sell the farm up and get rid of the farmer. And the farmer claimed that the bank had engaged in deceptive conduct and that he, the farmer, was entitled to have a defence against the bank. Even though he wasn't paying the mortgage, he claimed that he'd been misled into joining the mortgage, signing the mortgage, and that he should be given relief by the court. The judge heard the case, and at the end of the case, the judge dismissed the defence, and the farmer lost. And when the decision was announced, the farmer thought, I wonder if, and he went out, and in the way you can now, he tapped up the share registry of the bank, and he found that the judge, a very distinguished judge of the Supreme Court of Victoria, was a shareholder in the bank to the tune of about $300,000. And the judge had not disclosed this shareholding to the farmer. And so no one seriously suggested that the judge was personally corrupt or that the judge had made a decision to advance the value of his own shares. In the millions of shares in the bank, the decision in this paltry case wouldn't have altered in the slightest the value of the shares in the bank owned by the judge. When the matter was drawn to the judge's attention and to the attention of the Court of Appeal of Victoria, the judge made a statement in which he said that between the hearing of the case and the giving of his reserved decision, his mother had died, and his mother had a parcel of shares in the bank. That parcel of shares had passed to him as the executor of the mother's will. The mother's will left most of the shares to the judge, so he was both the executor and the beneficiary of the shares. The farmer said, I am entitled to have a judge who is not a member of the bank, who is not a participant or in any way involved with the bank. That is what the independence of the judiciary means. It means independent of the parties. And this is a breach of a fundamental principle. You should have drawn this to my notice the minute the parcel of shares passed into your hand, so that at least before the decision was given, I could consider whether or not I would require the matter to be heard again. That then would have been a matter of conscious waiver on my part if I had decided to go ahead. Now the case, the claim to disqualify the judge was lost before the judge. He refused to disqualify himself or to set aside his decision. And it was rejected by the Court of Appeal of Victoria unanimously, and it came up to the High Court of Australia, and the High Court of Australia divided. That's what we can do in our country. In some countries, civil law countries, judges can't dissent, but in British countries, countries of the common law, the judge is expected and required to give his or her honest opinion about the case. The legal test is a very clear and simple test. It's not complicated at all. It is, what would the reasonable person sitting at the back of the court think might have influenced the judge? Would it think that the judge might have been influenced? It's not just a question of was the judge influenced, it's a question of the appearance of justice and the appearance of the independence of the judge from the parties. There was a great case in England in the 19th century, and you know in the common law we'd look back at old cases to see how they've solved the problem, where a Lord Chancellor of all England, the highest judge in England, had heard a case, and the Lord Chancellor had shares in a canal company which was subject to the proceedings, and the court set aside the decision in which the Lord Chancellor had taken part, because they said the litigant is entitled to have a court that is unconnected with either side. But it was argued that that was too absolute a test, and that to run the case again would cost the community $100,000 because of all the costs, and there was no risk that the judge would have been affected. There was no possible risk that the shares would have been affected in their value, and therefore this one could be allowed to go through to the keeper and the judgment should stand. So I think you understand the arguments. The arguments, one might say, an argument of purity as against what would be put forward as an argument of practicality. There's no practical impact, but it doesn't look good, and the judge should have put them on notice once the shares came into his possession. Well, we'll now have an informal vote in this audience. You don't have to vote. You're not in a jury service now, but you've heard the arguments for and against given by learned counsel on each side, and you're now going to decide whether you think the decision by the judge should be set aside on the basis that the judge had received this partial of shares in the manner that I've described. Those who think the decision should be set aside, and then I'll ask those who think the decision should stand. Thank you. Those who think the decision should stand. Well, I think you'll agree that there's an overwhelming vote for set aside. Well, in the High Court of Australia, we divided, as I told you. The majority justices, 6 justices, said let the decision stand. I said let the decision be set aside, because though that will be costly, the value of a manifestly independent judiciary that is not affected by decisions is a pearl beyond price. It is something that is extremely valuable, far more important than an individual case, which is a case that sets the standards for all the judiciary of Australia, and that therefore the decision should be set aside and there should be a retrial. So my view of it was similar to the view of the majority the view taken by the High Court and the law of this land.
They're on your side.
What's that?
They're on your side, the majority of
Yes, well, they took what they would say was a very practical view and regarded as absurd to think that the judge's shareholding would have influenced the judge in the slightest, because his even $200,000 worth of shares in the ANZ Bank is not going to be affected by the number of shares he held, and that's not going to affect his decision. So what do we think about that? Is that a case of corruption? I don't think so. Is it a case of error of judgment? Well, views differ. The High Court of Australia has held that it isn't. I thought it was. He was a very distinguished judge. There's no way he would have done anything wrong deliberately. He was a very, very distinguished, uncorrupted, decent, honourable judge. And no doubt when his mother died, he was distracted by all sorts of other things. So there are all sorts of human explanations. But if you sit on a court like the High Court of Australia, you're not just solving the particular case. It's like the Communist Party case. When the High Court struck that down, it wasn't thinking of my Uncle Jack. It was thinking of what about somebody else who has some crazy ideas. The way to fight crazy ideas in a free society is with sensible ideas and with argument and with persuasion. It's not to deprive people of their civil liberties. And similarly, in a case like the case is called Klenai against the ANZ Bank Company, and you could look it up on the web if you want to, and it's simply a very little case, one of the many cases. But I tell you that case not only for its relevance to show that's the sort of case we get in Australia, not money in paper bags, but cases at the border where you can have different points of view. But don't you think that case illustrates very well how important the values of judges are? Because it's not as if you could answer that case flying the plane on automatic pilot. It wasn't a case of George, the automatic pilot, flying the plane. Every judge had to reach his or her own individual assessment. And different judges would have different assessments of the importance of the signal it sent, of the importance of adhering to the very stern principle laid down in the case of the Lord Chancellor in England. 100 years that principle had stood in England, of the importance of the cost of justice. Are we all getting a bit unrealistic and not paying enough attention to how much it costs to run these big trials? And of the reputation of the judge, is that a factor to be taken into consideration? The consideration of the attitude of a farmer taking on the world, taking on the ANZ Bank, one of the biggest banks in the nation. So I think that case is quite a good. Has anybody got any comments on that case? Anybody want to say anything about that case? Yes.
Does it show that the law is subjective?
Well, it shows, I wouldn't put it that it shows the law is subjective. It shows that the law depends on values, that the way law is expressed it's expressed in words of generality. What would a reasonable person sitting at the back of the court think might be the case of influence or appearance of influence? And that's in very general terms, and therefore decent, well-trained, highly skilled, uncorrupted, intelligent people can come to different conclusions. And what makes the different conclusion? Values, your values. What makes your values? Well, I think maybe your values are affected by your upbringing. For example, my upbringing was in a suburban home in Sydney with 3 siblings, loving young parents, public schools, going to public school in 1946, just after the war, I remember the children from the home, capital T, capital H, which was an orphanage, were coming in bare feet, and their first food of the day was the milk that was always left in the sun, which they would have as the compulsory handout of a small bottle of milk for all students in public schools. So I think that influences the way you look at things. And if you come up that route, as against coming up, say, a route where your parents, you've never seen anything like that, and you've been well off, and you know that courts are costly, and you've got to think about these things, then you're going to have a slightly different view than if you come up the other view, because then you're going to think, well, how is that farmer going to think about this? He's always going to think, I was done in the eye by a judge who had shares in the bank whose interests he upheld. And that is not a good look for the legal system as a whole. So can you see the dilemma of being a judge on the High Court? Can you understand that by that very homely and simple case? Please, if you take nothing else from my talk to you today, take this, that law is not a matter of objective certainty. Law is frequently a matter of evaluation, assessment, application of general standards to ever-changing facts on which decent, honest, uncorrupted people can reasonably have different points of view. It's very important you understand that, and that nobody jumps up and down and says, well, those judges in the majority in the High Court are corrupt. I mean, that would be a ridiculous conclusion. I don't suggest that for a moment. I respect the decision to the contrary. I've sometimes raised this case with judges in other countries because this is a problem that could arise anywhere. And generally, the English lawyers say we would stick to the principle laid down in Dimes's case, D-I-M-E-S, which was the case of the Lord Chancellor 100 years ago. We would stick with that. For the sake of a retrial of one case, we would be prepared to pay that to hold the principle very clearly so that every judicial officer in the land knows the rules clearly. And you can't have even a cent interest in the party who is before you without disclosing it and getting a waiver or a request that you recuse yourself. Just as I recused myself in that case involving the two gay men from Tasmania. I couldn't take part because I had had a contact with a party. And so I didn't even ask for them to waive that. I thought that is not something which I should sit in because everybody is entitled to have a judge who is not connected at all with the issue. So I think I'm consistent with the way in which I approach it. And I suspect that seeing those little children coming from the home near Corries Avenue in North Strathfield, Sydney, Australia in 1948 burrowed away into my mind, and I feel I'm much closer to the perspective of that milieu than many others will. Somebody up the back had a question. No? Yes.
This question of relying on values, doesn't that bring into the criticism of yourself and others of being political activism?
Well, it certainly leads to people making those accusations, but my own view is that that is a very naive way of looking at the nature of law. That comes from people who want law to be absolutely clear, no questions. And there are some lawyers who think that the law is very absolutely clear, but my experience in many, many cases, and I've just given you that one illustration, is that the law is often not clear. And what are you to do then? You have to decide the case. Now, did you think that was activist of me to decide that way? There would be some who would say it was very activist of the other judges to overrule an authority of 100 years involving the Lord Chancellor of England in the same legal tradition. So who is the activist? The judge who sticks to the old principle and does so for reasons which are explained of the values, or the judges who say, well, we'll set aside that precedent and we won't apply it in Australia and we'll look to the practicalities. Now, who are the activists? So you've got to be very careful with this use of the word activism. Activism is a sort of code language used generally by conservative people but then when you point out, well, sometimes conservative people have been a little bit activist for their own interests, and maybe wealthier people are more likely to have or have had shares and can be more understanding of the slips that can happen with their big fat share portfolios than somebody like me who never bought shares because of the fact that it would cause too many problems in the courts. Any other questions? Yes.
But how do you differentiate values like?
Right.
Don't you think volition and values are interrelated? How do you differentiate values from volition?
Values from volition.
And establish an opt test.
Well, that assumes that you can hope for something more objective than you get. What you get is people who aren't in the pay of others, and hopefully people who will be candid about the factors that influence them. If you look at the reasons of the High Court in that case of Klenai and ANZ Bank, it's in about the year 2002. If you look at it, you'll see both sides were candid about the considerations that were influencing them. And given the opaque nature of the legal test, which is often the way, especially by the time you reach the High Court of Australia, if you go up to the High Court, then by definition it's gone through two other phases of the legal system. You're going to have different viewpoints, and they will be thrashed out in the court in a public hearing, and they will then be expressed in the reasons of the judges. But as to volition, well, I think it's important for judges, and indeed all decision makers who have public authority to make decisions affecting other citizens. It's important for them to search into themselves. What are the reasons why I am reaching? Why did I reach that decision in the case involving the judge and the shares? Why did I reach that decision? Well, I think I reached the decision because I thought it was very important for the independence of the judiciary to have judges who had no connection with the parties, not even a cent, unless it had been revealed. And I don't think that's a question of inhibition on volition. I think it's a question of being truthful about the things that influence your decision making.
I'd like to get some questions from other campuses. I want to get as many questions in as possible, but I'm wondering if we could start and work our way up the coast. So, Bega, might there be any questions from Bega? Then we'll go to Batemans Bay, Shoalhaven, Moss Vale, and then we'll come back to this audience here. But first of all, I'd like to give as many opportunities to the remote campuses as possible. So, if there's anyone from Bega who has a question for Michael.
Yes. Yes, we do have a question for Michael.
Far away.
John Teller, I'm a chairman and a stirrer of an environmental group.
Oh, one of those.
Returning environmental flows to the Snowy River. But we have a problem with a New South Wales government who does not comply with its own statute. And as a stirrer, I take great offence that the government do not comply with their statutes. We have to comply with statutes that are imposed on us. How do you make the government comply with its own statutes?
Well, if you don't have to be a stirrer to be upset if a government doesn't comply with the statute. I mean, the statute is made by Parliament and it binds the government as it binds everyone else. The problem is often what the statute means. But if you are a person affected by a government which is not complying, or a minister or authority which is not complying with the statute, then often you will have a chance to go to the Land and Environment Court and say just that, and have the court require the government to, or the minister to adhere to the statute. So that's not being a stirrer, that's being simply a matter of being a citizen and insisting on the rule of law in our society. Now, I suspect that your next question is going to be trying to get me into your particular little concern. And I've gone out of the business of giving legal advice. So I can't take that next step with you, I'm afraid. But if you are right that the statute is not being complied with, well, depending on your having the standing to raise the matter, that is to say, having enough interest under the land and environment legislation, then you will have a remedy. I did a lot of land and environment cases when I was in the Court of Appeal, and it is a hotbed of litigation, often brought by powerful and moneyed interests, but sometimes brought by community groups to uphold the environmental legislation of the state, which is quite complicated, but very interesting. Any other questions from Bega? What's that?
You give me great confidence. Thank you.
Well, I hope, I can tell you the judges of the Court of Appeal do a lot of land and environment cases on appeal from the Land and Environment Court. And the Land and Environment Court is actually a very interesting experiment. It's looked at by environmentalists all around the world as a special environmental court with a specialist expertise in this rather technical and complicated area, but lying behind the technicality and complexity of the environmental law are often very important principles for the better protection of the environment in which we all live. Any other questions from Bega?
I think that might be it from Bega.
All right.
I can say to the gentleman from Bega that although Michael might be formally out of the business of giving legal advice, he does have a very funky website which has an interesting little item on it, which is the Contact Me site. So if you click on there, you can actually write to him. And I can give you that website if you like. And it has an email address. And so Michael also doesn't sleep. It's true. It's all true. Anyway, Michael doesn't sleep. He answers my emails at 6 in the morning. And he would be delighted to answer your questions, I'm certain. Yes. Having solved that, we can now move up the coast to Bateman's Bay. I'm wondering, Karen, do you have any students there who might like to ask a question? Perhaps not. What about Shoalhaven? Don't rush.
Mr. Kirby, I'm interested in your comments on how the Howard government managed to excise Australian territories in the light of asylum seekers trying to make their way to this country, and what do you think of that set of circumstances that occurred?
You're just trying to get me into a political hot water. It is true that the former government did redefine the area of Australia into which applicants for migration status must come in order to activate the Migration Act 1958 for the purpose of seeking protection visas as refugee applicants. A question does arise, which has never been determined so far as I know, certainly not by the High Court, as to whether given that Australia ratified the Refugees Convention and Protocol of 1951, and given that that speaks to nation states, and given that nation states are normally defined by the territory of the nation state, which is part of the sovereignty of that nation state, whether it is open to a country conforming to the international treaty to redefine its own territory for that purpose of activating the obligations under the Refugees Convention and Protocol. It may be that the answer to that question would be that Australia cannot, in international law, redefine itself, but for its own national domestic law, it can and has. But whatever the answer to the question, that issue never came before us in the High Court of Australia. It certainly is an oddity to sign on to an international treaty that binds the nation and then say, well, we're only going to apply this, say, to the nation in respect of the Australian Capital Territory. Could our government or our parliament do that? Well, the logic would seem to suggest that it could, but it would be a very, very odd result. And you've got to test propositions such as redefining the territory of Australia for the purpose of enlivening the refugee entitlements by an absurd illustration, such as confining it to Bateman's Bay or confining Australia to Wollongong. But the question never arose in the High Court, though I imagine that over there in Geneva, in the office of the High Commissioner for Refugees, some people would have looked at it and said, what's this? Australia signed on to this treaty. Australia includes the island territories and various other parts for the purpose of the sovereignty of the Commonwealth of Australia, but it's not going to recognise people who come to those parts or their territorial waters for the purpose of according them refugee status under international law. Unfortunately, it's one of those many illustrations of the fact that it doesn't seem to matter who is in government. This is not something that began with the Howard government, as you described them. Whether it's a Labor government or a coalition government, governments of Australia tend to pander to a lot of xenophobic attitudes in our community, which are fed by news media organisations, which whip up a storm of anxiety and fear, when the plain fact of the matter is that in our country, 96 or 97% of refugee applicants arrive in a comfortable seat in a plane. They do not come on boats. It's a tiny trickle, and compared to the huge numbers who turn up every day at borders of Austria and of France and of the United Kingdom, the trickle that we have in Australia is pathetically small. And yet if you want to get Australians excited and upset and angry and political, you just have to raise the fear of the floodgates. I'm old enough to remember those floodgates of the Chinese. The Chinese are coming. They're going to swamp us. They're going to destroy us. And they're dirty. They're not like us clean Aussies. Well, I hope we've got over that, but we certainly haven't quite got over all of our xenophobic attitudes. And unfortunately, it doesn't seem to matter who is in power. Mr. Jerry Hand invented a lot of the laws which are still in place to lock up refugee arrivals on boats. We have a thing about boats, though most of the people in this audience or their forebears came to this country on boats seeking to make a better life for themselves. So don't ever forget it.
Just going back to Bateman's Bay for a moment, Karen, I'm wondering are there any students from there who have a question?
Yeah, hi there. Thank you, Michael. Unfortunately, we're having lots of technical glitches here. We're dropping in and out all over the place, as you can probably tell from up there. But do we have any questions off the chance? Yes, we've got one. Michael, what do you think about a Bill of Rights for Australia?
Well, I'm glad you raised that question. If I hadn't overshot my time, I would have come to the Bill of Rights eventually. I'm in favour of the Bill of Rights for one fundamental reason. And the fundamental reason is why Mr. Bob Carr and other politicians, on both sides, by the way, of the political divide, oppose it. and that is it is empowering of little people to be active in a cause and to get their voice heard. It doesn't, under the proposal put forward by Professor Brennan, mean that they'll get immediate relief. The charter proposal, as you know, that Professor Brennan has put forward, doesn't mean that if a court holds that it can't read down the legislation so as to conform to the Charter of Rights, and it holds that the legislation is in breach of the Charter, that doesn't give the court the power to invalidate the legislation. And that's a very important point. All it does is give the court the power to make a declaration of inconsistency with the Charter, and that, it is hoped, will give the person who's made the complaint a tool with which to agitate for legislative reform. Now, far from that being something inconsistent with the parliamentary process, that's something that works the parliamentary process. But that may be why so many people who currently have the levers of the parliamentary process don't like it. Because if you have an alternative way of working the parliamentary process, which still comes back to the vote of the parliamentarians, then you are given a little bit of traction on the greasy pole. It's very important to realise that that's what this debate is about. It's why of the 38,000 citizens who made submissions to the Brennan inquiry, 36,000 favoured having some form of Charter of Rights. And the reason they do is that many people have become very disillusioned with the involvement and participation of Australian citizens in the lawmaking process in Parliament. They are disillusioned with the fact that the Parliament has fallen under the power of political parties, which, by the way, are made up now of an increasingly small and smaller cohort of the citizenry, in branches which often have very small numbers turning up, deciding the electoral representatives and having a power over the whole process completely disproportionate to the number of people who participate. In such an environment, the more that we can do to raise the voices of the people, to raise the people's capacity to be heard, even if they can't control the process, as they can't under the Brennan proposal, even if they can't insist that what they say be accepted, merely have it considered by Parliament, that makes the responsibility and accountability of Parliament much more clear. And I myself think that would be a very good thing. So the answer to your question is I'm not in favour at the moment of a Bill of Rights in the American style. Secretly, I probably would favour that, but I'm keeping that to myself at the moment. But just as in Canada, where they took this step first of a statute, an Act of Parliament, this is all that is proposed now, not a constitutional change, an Act of Parliament, a first step to get us over this terrible problem that Australians have of hostility to a notion which is accepted in virtually every other democratic and advanced economy in the world. So I'm in favour of the charter model that's put forward, and I think it is a step in the right direction. And I'm not surprised by the enemies who have lined up against it, because they don't want anybody else's voice having anything to do with the lawmaking process except their own.
Okay, Penny, I'm wondering, is there anyone at Moss Vale who might have a question?
No, Michael Kirby just answered both aspects of the question we were going to ask.
Excellent.
So thank you.
Okay, so last call for anyone on the south coast of the Highlands to ask a question before I start and roam the microphone around this auditorium.
Just one Shoalhaven.
Professor, I would like to ask a question. Can you hear me?
Yes.
Yes, go ahead.
Mine's a banking question. My wife and I, we had a very successful business, and we have lost everything. And the bank, by defrauding my wife and I'll tell you how they did. We were to pay.
Excuse me. Can you please cut straight to the question, or there will be no question.
Okay, fair enough. Well, the bank charged us, instead of 5 to 6%, they were charging us round figures of 50% interest. Then the bank staff added on two amounts of troublesome interest, up to 25% each. That's 100%. Then they added on shadow ledgers and up to 25%. That's 125% interest. We have been from the Supreme Court to the High Court, Federal Court to the High Court. Judges have continuously struck out our subpoenas, denied us access to documents of a notice to produce, denied us discovery, and then written judgments against us. And the Foreign Borrowers Association gave evidence to the margin banking inquiry. They said they'd done a survey on judges and found that any judge that handed down a judgment against a bank did not sit on another bank case. Now, this is in Hansard. Now, with the support of Austrade, Lights Out...
And your question is?
Where do people go when the judges will not abide by the law?
Well,
because it's against the Evidence Act and the Federal Courts Act what they have done.
Well, I've learned one thing over 35 years, that a complex sort of a problem, such as you have obviously gone through, can't be satisfactorily summarised in a few words and in a public forum like this. You've got to sit down for a day of your life, begin at the stage one, work your way through the whole files and read all the decisions, and then reach a view at the end of the day. And that wouldn't be respectful to you or to the other parties or to the judges involved for me to express an opinion without doing that. I mean, it just wouldn't be fair, and it's not the sort of thing that a High Court judge or an ex-High Court judge should do, so I'm not able really to do it. But I think it shouldn't be said too easily that the judges have not been willing to apply the law, because that is what they're there to do. They've applied what they understand to be the law, and if you have taken it to the High Court twice, as you say, and you haven't had success, then I think the reality would appear to be that you are at the end of that particular road. Courts can often fix up things. Courts can often reach just conclusions. Courts can sometimes correct mistakes that the courts themselves have made, as happened with me in the Mallard case, which was a case of a man who was convicted of murder and sentenced to life imprisonment in Western Australia. His family stuck by him. He kept agitating his innocence, and eventually he came back to the High Court 10 years after I had been party to the original decision refusing him leave to appeal. And on the second occasion, with different arguments, he got leave to appeal, and he won his appeal unanimously, and he was freed from prison. So that can happen, but it's a very rare instance, and you've got to face the fact sometimes that courts can't fix up every problem, and particularly if they're not helped with the best of legal advice and legal assistance. And if that is the case, then you've got to be very cold and realistic and look at the value for money and decide whether or not it's really worth putting more money in the bucket which hasn't succeeded so far. And sometimes in those circumstances you do best to draw a line in the sand and say, well, I think they were wrong and I think we were right, but we're not going to spend any more money on that endeavour, and we're going to get on with our lives and get a real life, not a life hanging around courthouses. Because I can tell you, as somebody who did that for 35 years, it's not always a real life. Any other questions? Yes.
We need to go for questions from here. we need to go to a microphone because that way all the other campuses can hear. So this microphone is now going to have to work its way around the auditorium. And brevity is
the soul of wit.
Michael, I'd like to take you back to the Communist Party dissolution case. I was astounded to hear from you that the majority in that case was 5-1. And my question is, do you think that knowledge of the then Prime Minister's former legal career had any influence on the decision?
First of all, it was 5-1 because one judge didn't sit, Sir William Webb. I think he was involved in a war crimes trial immediately after the war, or for some reason he didn't sit. And that's why it wasn't 7 justices. Normally in a big constitutional case the 7 will sit. Secondly, what influenced them? No, they were divided. Chief Justice Latham dissented, and Latham wrote a very strong dissent in which he said, as Cromwell had written at the time of the Commonwealth, being comes before well-being. In other words, the communists' attack on the constitutional fabric and of the type of democracy Australia had was something so fundamental you had to respond to it. It wasn't just another case of what's good for the well-being of Australia. This was about the existence and the nature of the governance of Australia. So he had an argument. And interestingly, in the Thomas and Mowbray case, which was the case about Jack Thomas, you remember the man in Victoria, and the control orders, Justice Callanan in the High Court said that he thought Justice Latham had been correct. So we shouldn't assume that the Communist Party case is rock solid. There are still those who think it was wrongly decided. But why did the other judges hold that view? Well, that is best expressed in the reasons of Sir Owen Dixon, a very great Australian judge who was the leading writer for the majority opinion. Sir Owen Dixon said, history, and not only ancient history, reveal that it is often government that tries to take away the liberties of people, and that is why you have to have courts, and that is why courts have to be vigilant against that risk. I don't think that Sir Robert Menzies' past role as a barrister, and he was an absolutely sublime barrister. If you remember, you would have only been a little whippersnapper and a boy at the time, but he had a wonderful voice and a great presence and great wit and wonderful aplomb, and he was a great success as a barrister, and he would have been a great judge. But he turned to politics and he became the longest serving Prime Minister this country has had and probably ever will have. But I don't think there would have been any feelings against Menzies. On the contrary, Menzies was deeply shocked when the decision came down, deeply shocked, and greatly surprised, because just before that, the US Supreme Court, with all of the provisions of their Bill of Rights, had upheld the Smith Act in the United States, which does go to show once again how important the values of judges are. And I think the judges of the majority in the Communist Party case took the view, well, we've got plenty of law, sedition law and criminal law, to deal with communists if they start doing nasty things to other people, if they start heavying them or involving them in inappropriate union activity or inciting rebellion against the state. We've got plenty of laws to deal with that. We're not going to invade the ultimate privacy of their brains. We're not going to disqualify them from civil liberties for what they believe, because to start down that path is to start down a path the ending of which you can't be sure. And it may then involve people's religious faiths or people's other political persuasions or social points of view. And I think that was what moved the majority justices, and frankly I think they were absolutely right, spot on, because the way to tackle people who do antisocial things is to seize upon what they do, not on what they believe or think. And that's why we kept in Australia a relatively free entitlement to express our different views, and I hope we always will.
Michael, you spoke about the great satisfaction you have in Australia with independence in the judicial, but at times there is perversions of justice done by lawyers with conflicts of interest in industrial grievance courts and in voluntary societies like churches. And there's a real problem that where Sir Anthony Mason in a Fijian deportation case about 86, initially in a minority judgment, proved that the right of natural justice and due process apply wider than just in the courts in our Australian society. But that very right to natural justice and procedural fairness is at times completely denied by churches in covering up misconduct. And I guess the question is, do you have any advice as to how we can deal with that?
Well, first of all, there is no doubt that natural justice doesn't just apply to courts, or it also applies to government officials and to tribunals and to other bodies that are on the federal payroll. We had a very important case in the High Court concerning the wheat board, and they had privatised the wheat board, but by an analysis of the legislation, it was shown that the wheat board, still were in receipt of some federal gold. And for me, that was enough to make them answerable to the rules of procedural fairness, natural justice. And I said so. This was before all the problems of the wheat board blew up. This was a group of farmers who were trying to make the wheat board answerable for what they were doing with the one desk policy and their overseas dealings, but the majority of the High Court held the other way. You may have gathered that from time to time I was in dissent on some of these cases, but the majority held the other way. I must confess to you that when all of the problems broke out with the wheat board subsequently, I was inclined to feel, though I didn't say anything, I'm saying it now, I told you so. But that is just the nature of the independent judiciary. They reach different views, I reach my view, and I expressed it. But the principle at the moment is, as I understand it, if you take governmental money, then you are subject to the rules of natural justice. If you don't, then you're not. Now, there may be a question with churches, especially for schools, where they take government money, as to whether that should not introduce into the law of natural justice the principle that it extends to that type of case. That hasn't, as I understand it, been decided yet. In England, there have been decisions holding that the stock exchange, which is a private organisation, is subject to the rules of natural justice, because the English judges have said it's in the nature of a body which should be accountable, and therefore we'll make it accountable. As to what can be done in Australia, well, I'm not at all sure. I mean, I would have been inclined to extend the principles of natural justice to public or quasi-public bodies. But I could understand that there would be many of the conservative legal disposition who wouldn't. Another case of values. Why do I think that? Because I think it increases accountability and transparency. Why do others think not? Because it's more consistent with an old-standing principle, but not the old-standing principle of the Lord Chancellor, which has to be set aside because it didn't work in that particular case. I don't think we'll see any big change in that in my immediate lifetime.
Michael, with respect to values of law, is there scope to integrate our common law with Aboriginal law and Sharia law, or should they all be separately parallel together?
Well, at the moment, the common law does not take into account directly issues such as Aboriginal customary law or Sharia law, or for that matter, Christian law, except insofar as it has been incorporated as part of the old common law of England. What we should do, well, the judges of the Northern Territory, because they were the ones who were actually seeing cases of people who had been taken out and speared according to Aboriginal customary law. The judges of the Northern Territory began in a case called the Queen, and I forget the name of the case, but it was Sir William Forster, a very wise Chief Justice of the Northern Territory, said, well, obviously, if they've been punished according to Aboriginal customary law, we will take that into account in imposing the punishment according to Australian law. Australian law still applies, but to avoid double punishment, we will take that into account, which seemed a pretty sensible sort of reason. Subsequently to that, the Federal Parliament enacted a law saying specifically that that could be done. But then about 2 years ago, the Federal Parliament repealed that law and said courts are not to take into account Aboriginal law. I fear that that was a matter of ideology. There were ideologues came into the debate. The Australian Law Reform Commission produced a big report on Aboriginal customary law, but save for a few exceptional recommendations, it hasn't been passed into law, and I don't see that happening anytime soon. As to Sharia law, the law in Australia would be that that could sometimes come to be taken into account in very limited circumstances. Take, for example, a case of provocation. What would provoke a reasonable Australian? Can you take into account the Sharia or the Islamic or any other religious or cultural phenomenon, or is that to be completely disregarded? I don't think that issue has been finally resolved as yet. But you do get cases at the borderline. A case came up in the Court of Appeal. I didn't sit in it, but I would have decided the same way as the court did, in which the issue was whether a private prayer place of the Islamic belief should qualify as a public place of worship for the purposes of certain tax entitlements to be removed from having to pay local government taxes. And the Court of Appeal held yes. The argument against was that this was a fairly strict branch of Islam that wouldn't allow non-believers in, and therefore it wasn't public in the sense that it was available to all members of the public, but the court held it was available to all relevant members of the public, namely the public who wished to go and worship in that particular branch of the Islamic faith. And I think that was a sensible decision on the borderline of using, recognising the multicultural nature of our society. But it was, in the end, an application of an Australian statute, public place of worship. And it was just a question of applying that to the facts of the case. But there's no wholesale importation of Sharia law or customary law of the Aboriginal people, and I don't see that happening in my lifetime.
Okay, we've got time for, I think, two more questions. And I'd like them to be questions, please.
Has there been any other prior examples of civil liberties issues regarding community activists being put into dossiers by authorities that are incorrect, incomplete and also misleading, as well as to that then make the use of FOI legislation to release the document unedited so that they can't be defamed, but yet, well, so they can't have a defamation suit against them, but yet won't release it under Section 12 publicly because they're concerned about defamation?
Well, I'm glad you asked that question, because when I left the High Court, I packed up an enormous amount of paper I'd kept everything over the years, even bus tickets, and that all went off to the National Archives. And the National Archives of Australia, which is a wonderful institution, which does keep officials' papers, said, well, we want to do something for you in return. And what we're going to do is to give you your ASIO file, which has recently been requested. And the ASIO file was of a file which was opened in the 1950s when I was a university student, and I was a member of that extremely dangerous and subversive organisation, the Sydney University Students' Representative Council. And after that, I was a member of the Malaysian Students' Association, and it has. And I also, as I've told you, was a member of the Council for Civil Liberties. And all of these past actions are recorded. All of these these boring, tedious committee meetings I attended, all of these speeches I gave at functions, many of them even more boring, will you believe, than the speech I've laid before you today. These speeches are recorded and duly noted by some official of ASIO who was there in the back room looking at me. There is also a priceless document which was a record of a conversation between an ASIO agent and my Auntie Glory. Now, the document has up the top a statement to the effect that this was non-gratis, which I rather assume means that this agent was being paid for his intelligence. And my Auntie Glory was the sister of my grandmother, who had married, that was Norma. She married, they all had these wonderful names in those days, Norma, Alma, Caroline, Lillian and Gloria. Gloria was a feminist. She was an out-and-out feminist. I don't know that she was a communist. She was a great friend of Lady Street, Jessie Street, and she believed that women had rights, which was a very peculiar view in those days. Anyway, they went up to her and they asked her about her nephew, and she said, Michael Kirby is very brainy, but he is a hopeless reactionary. And you know, thinking over it, I think she might have got me right. I mean, I am self-evidently very brainy, but I also am, in fundamentals, I'm really quite conservative. I mean, I do believe in our institutions. I do believe in our judiciary. I don't believe judges are corrupt. I do believe in the rule of law. I do believe in the parliamentary process. I believe in improving all these things, but I believe in our institutions, and I do believe that we are better off than most countries in the world. But I do believe we can continue to improve things. So if you think about it, that's really quite a conservative view. The real conservative will seek to make the institutions work better. It's dangerous people that don't care and leave them to fester and to fall into the hands of a few, and not to be answerable to the people who are the ultimate sovereign in any country.
Okay, final question.
Thank you. Michael, could you please give some, I would like to ask, how can a community act against a repressive New South Wales planning legislation government when everything you've tried, the minister has shifted the goalposts and you've had to go back to court again and again and again, and the legislation becomes cumulatively more repressive and you never seem able to overcome it, you know, in various EP&A matters.
Well, I understand the question, and I can understand that maybe a lot of people here, because your focus has been on community and local engagement, are very concerned about these sorts of issues. I don't know the particular case you're referring to, so I can't comment on the particular case. But if you reach the end of the road, you have to do what I told the other gentleman who'd been through the courts. You have to either essentially draw a line in the sand and say, well, I did my level best. I did my best. I did not succeed. I'm going to get a life. And there are other things. There are roses to be smelled and other such things. Normally when people say to me, why don't you smell more roses? I say, hang the roses. I don't want to smell the roses. I want to get on with it. And therefore, if you then don't go into the rose smelling mode, you have to take one of two steps. Either you have to continue down the litigation path, but that doesn't look as though that's going to be useful if the goalposts are moved, or you have to take the political path. And the political path has its own problematical nature because of the fact that the political parties, largely through disillusionment of our people, are falling into the hands of fewer and fewer. Fewer and fewer people are willing to join political parties and go through the highly factionalised process of political parties today. And this is a big worry for our system. And I think John Hatton is onto a very good and important point. How can we keep the strengths of our institutions, which, let's remember, were secured by struggles over hundreds of years? We are the inheritors of the struggles of the people of England, who were in advance of all the peoples of Europe in cutting off a king's head, banishing another king, and upholding the rights of the people. How can we uphold the rights of the people today? And I think John Hatton, who's been on about this all his public life, is on to an important issue. How do we keep our institutions of Parliament and the courts, but make them work better? And I think that is what this series of seminars should be focusing on. What are realistic ways to get that done? What are realistic ways that are not just going to be dismissed by those who have the levers of power? If you have the levers of power, you are not going to be willingly handing them over. It has happened once or twice in Australian political life. It happened in South Australia, you remember, when Premier Steele Hall had the gerrymandered Playford upper house, and he could have stayed in control of the upper house forever. But he was a Liberal Premier, and he said, this is not correct, and we're going to get rid of it. And that was a very brave thing. It does happen sometimes, but generally people who have control on power don't like to give it up. And so for them to be persuaded to do that, you have to have pressure. And where can the pressure come from? Put not your faith in the media. The media are only interested in sensation. Look at this business now of getting them to write in the Telegraph to the Governor, to Her Excellency the Governor. What can the Governor do? What should the Governor do? She should tear them all up. She can't take advice from citizens telling her to sack the government. That would be constitutional revolution. That would be a very wrong thing for the Crown's representatives to dismiss the government on pamphlets torn out of a newspaper. I saw the other day, this is something the Sun newspaper tried in England against Mr. Brown about a year ago, 2 years ago. So all the Murdoch papers copy this around the world, you know. They're probably doing it in the New York Express, and they're probably going to do it in the Denver Herald, and all of this, it's all just somebody's gimmick, and it has nothing to do with how you change government. The way you change government, ladies and gentlemen, the way you change governance is here this afternoon. Citizens are worried and they're concerned. They get together, they talk about it, they think, how can we organise ourselves? Does it mean gulp that I've got to go to those prawn and beer nights in the ALP or the Liberal Party? Do I have to really put up with that? Or are there other ways that we can persuade good Liberal people or good Labor people to change the way we're being governed? And that is why you are here, and it's a good thing you are here. And it's why I came down, apart from the fact that my father told me I had to.